Good morning, everyone, and welcome to the webinar on IHI's Rules and Procedures. My name is Catherine. I'm a member of the communications team, and I'll be moderating today. And joining me here is Tom Shannon, another member of the communications team, and Desmond Barry, who is one of our legal officers, and he's going to give the presentation today. Before we get started, just some housekeeping notes. We are recording the webinar, and we're going to publish the recording and the slides on the IHI website later. And another very important point, we obviously haven't yet launched the call, so any information on future IHI calls should be considered indicative, subject to final approval by the IHI Governing Board. And as soon as that happens, we'll publish all the documentation online in its final and definitive form, and you can go and look at it. So on that note, I will hand over to Desmond for the presentation.
Thanks, Catherine. Good morning, everyone. The plan here is we have a series of slides, and we're going to talk about first the general principles, then we're going to dive into such concepts as eligibility and types of participants. Then we're going to look at some funding issues, and then we're going to look at kind of related concepts, for instance, like intellectual property, and then we'll round it out with some Q&A. So what I'll do is I'll try and explain everything in a nice steady pace as we go, and if you have any questions, just flag them. We can cover them off at the end. I will add as well that if something occurs after seeing this, we actually do have an infodesk facility here at IHI, which is monitored by staff, and the IHI legal team contribute to this. So if you have any questions after the event, please feel free to send a question to the IHI infodesk, and we'll deal with it just as quick as we can. Obviously, at the moment, we're receiving quite a large number of comments systematically, but we are working our way through them. So we'll start off on the webinar on IHI Rules and Procedures. And I'm just going to go through the outline here. So as I said, we're going to talk about some general concepts for IHI first. Then we're going to talk about the participation rules, funding rules, IP, and then some practicalities from call to grant award, points to remember, call timelines, and then we'll have a quick slide on the reference documents as well, which we think provides some additional useful information for anyone who wants to delve deeper into the subjects. So when we talk about introducing IHI, as we know, it's a new partnership in health between the EU, and that's obviously represented by the European Commission, and then we have the private members. Those of you who are veterans from IMI 1 and IMI 2, which you'll recall was a partnership between the EU and the Pharmaceuticals Federation, FPA, you'll note that we have a much broader group here. So we're basically bringing in COSIR, who specialize in medical imaging, radiotherapy, and health ICT. FPA, of course, which includes Vaccines Europe. Then we have Europa Bio, which is biotech, and we also have MedTech ourselves, which represents the medical technology industry. Again, those of you who will remember IMI 2 will remember that we had a very, very successful associated partner program. I'll talk about this a bit later on. This is now reflected in IHI with the contributing partners. So for those IMI 2 veterans, I would just flag this in case you don't already know. If you were familiar with associated partners and that program, whereby we brought in, philanthropic organizations and funders for IMI 2, it's essentially the same program. It's just been renamed as contributing partners, and we're going to take a very, very similar approach to bringing in these very valuable groups. Then our general objectives for IHI, I mean, as a lawyer, I would say we take it directly from the legal basis, but we can broadly define our general objectives as we're going to turn health research and innovation into real benefits for patients and society. And I think this is something that it's very, very clear in the IHI legal basis that, they basically want to see downstream benefits for the population. Deliver safe, effective health innovations that cover the entire spectrum of care, prevention to diagnosis and treatment, particularly in these areas where there is an unmet public health need. And you'll recall that that's very similar language that we had for IMI 2. And then 3, we want to basically encourage processes and collaborations whereby Europe's health industries become more globally competitive and can take on the other blocks. So I think we can regard that as a broad statement of the objectives of IHI, and obviously then we have quite detailed instructions as to how we're to carry that out and other goals. But if we keep those 3 points in mind, I think that will inform the process going forward. I'm just going to make a quick slide here in relation to the strategic research and innovation agenda. So here we have 2 points here on focus and goal. The key point of the SRA is that there is a cross-sectoral approaches to facilitate creation of new products and services to prevent, intercept, diagnose, treat, and manage diseases and foster recovery more efficiently. I think that's quite clear. And then the goal of it is to lay foundations for development of safer and more effective healthcare products or solutions that respond to unmet public health needs. That's that phrase again. And that can be implemented into healthcare systems. So again, we want basically outcomes which will have practical effects downstream. And this is something, we've highlighted this at the bottom of the box, and this is something which I think informs all the IHI projects and all the work that we do, is that the research that we do in the actual JU should remain at the pre-competitive level. I think that feeds in very well to the collaborative aspects, and then also from a lawyer's point of view, I would view this makes it easier as well for all the companies to come and bring their assets with security in relation to their IP concerns and that sort of thing. So it brings a certain security to all our participants. Now we're going to jump into the actual participation rules themselves. So you will recall, if you were involved in IMI2, that all of our calls were essentially two-stage calls. A big departure here is that for IHI, we will basically be running both single-stage calls and two-stage calls. And this has a number of different implications, both in terms of the consortia that respond to these single-stage and two-stage calls, and also even the rules themselves, which are implemented at different points. So we basically tried to encapsulate here, if someone was going to summarize what the differences are or what the characteristics are of the single-stage and the two-stage calls, we have it here. So as we said, the single stage calls, they're extremely open. You basically have a full consortium who are organizing themselves. It's incorporating public and private actors. They organize themselves, and then they basically compete for funding against a funding amount which is set out. This is clear and self-explanatory. Two-stage calls, by definition, are a little bit more complex, but we're very used to them, obviously, from IMI2. And essentially what we have here is we have at the very start an applicant consortia, which is normally drawn from academics and SMEs. They actually prepare a short proposal, which then goes into the stage one evaluation, the evaluation of the first stage, which is a competition. And then it's envisaged that all of those applicant organizations in that stage are basically requesting funding. And then the winner of that first stage process then is invited to merge with what we call the predefined industry consortium. And when we say predefined or pre-identified, what that means is basically that in the call topic text, in a two-stage call topic text, we identify ahead of time who the actual industry consortium are, and we have indicative figures as well for the contribution they're actually going to bring. And then basically when that predefined industry consortium has organized itself, then essentially they apply for the second stage, and in the second stage, then obviously we launch an evaluation procedure again to make sure that it's viable. So that's our points on the different types of consortia. And then when we talk about how does IHI work, I've kind of referred to this already. If we look at it on the left-hand side with the actual call launch, we basically say that we have the topic texts there are going to obviously be approved by the IHI governing board, and they're in the annual work plan, which lays out all the topic texts and specific conditions. Then we basically go to the single stage, and we have these full proposals from the applicant consortia, and we do the evaluation process, and then we go to the actual granting phase after the evaluation stage is actually finalized. And then once we're getting into the granting stage, you basically get to the point where the consortia are entering negotiations, they're preparing their consortium agreement. We're working towards signature of the actual grant agreement and project launch. And then we have two additional points here which might be useful. So as part of those panel deliberations, which is at the evaluation stage, we may organize hearings with the applicants to just clarify points in the actual applications to help the independent experts establish their final assessment and scores, and to improve the experts' understanding of the information presented. So we're flagging this to let potential applicant consortia know that when they actually send in their actual proposal, that it's important that they realize that there may actually be further questions raised at the evaluation stage. So that's single stage. And then if we actually go on and we talk about two-stage, as I said, it has a different structure because we have this predefined industry consortium in the mix and identified right from the very start in the call topic text. So we will actually launch the call, and again, we have the same thing. We have the topic texts. Those topic texts identify the industry consortium. Obviously, it's entirely possible that will be different for each call, or for each topic. Stage 1 is based on a short proposal, which is submitted just by the applicant consortia. Then questions that will actually be evaluated, and then, as I said, the winner of that process then goes through to stage 2, and that at stage 2, that applicant consortia has by then merged with the pre-identified industry consortium. They prepared a full proposal, which is then 50 pages. That's evaluated then at the stage 2 full proposal submission. And then, providing everything goes well, then it goes through to the granting phase. And again, we have what's called the consortium negotiation stage. We're finalizing the consortium agreement. We're working towards grant agreement signature. Just to remind everyone here, because we have it in the box, when we talk about grant agreement signature, that is the signature of the actual grant agreement. It's signed by the project coordinator and the executive director of Ihijuu, and then everyone else, all the other participants, will sign accession forms within a 30-day period thereafter. And that's basically project launch. So that's both our types of consortia, and that's both our single stage and two-stage procedure. As I said to those veterans of IMI 1 and IMI 2, the single stage might be a bit unusual or a bit unfamiliar, but single stage will obviously be very well understood. And to remind everyone, for the purposes of this, in terms of the two calls that IHR are going to be launching, call 1 is going to be single stage and call 2 is going to be two-stage. So if we move on to the actual specific conditions, we basically have a couple of points here. So for call 1, we have a launch date indicatively of the end of June of this year. That means that the deadline for submission of the proposals to the IHI office will be the end of September 2022. There are the basic legal minimum conditions for participation. Because this is a research and innovation action, we need at least 3 independent legal entities established in a different member state or an associated country. I'll come back to the associated countries a little bit later on. This is basically an established list of those countries who have signed agreements or are in the process of signing agreements to associate with the Horizon Europe program. And we've put this in bold. I think this is generally understood, but just to make sure, in relation to these 3 independent legal entities, it's absolutely essential that one legal entity should be established in a member state. And then we have a page limit of 50 pages for that full proposal, because we're looking at this once. So 50 pages, very, very clear. And then the conditions for the single stage to be continued is that all evaluated proposals will be ranked in one single list. And then proposals above the threshold will be invited to prepare a grant agreement within the limits of the available budget. So unlike two-stage, it is possible that we could have several winners of the single stage and that they would be invited to basically launch projects within the funding envelope that we have available for that call. Obviously, it will depend upon a number of factors, but there is that flexibility there, which we don't have at the two-stage process. And then, as we said here, for topics involving clinical studies, applicants should submit the essential information for clinical studies in the annex, and that will be in the templates that are available. This is an admissibility condition, so we would need everyone to keep this in mind. We'd also remind that for each topic, the maximum JU contribution is set out in the call text, but at the moment that is indicative. And also, in relation to the plan for dissemination, exploitation, and communication activities, this must be included. And if you're familiar with IMI 2 or Horizon Europe, what I would flag for you here is that we call it the PDECA. I think it's referred to as PDECA throughout Horizon Europe. This is essentially just the successor to what we did call previously the PED, or the Plan for Exploitation and Dissemination of Results. So if you're familiar with H2020 or IMI 2, there'll be nothing unusual here. And the template we will be using is exactly the same as the Horizon Europe template for this. So again, it shouldn't be anything too problematic. Moving on, conditions for the two stages, as I said, is slightly different, but the timing is similar. So we have, at least at the start, we have the call launch at the end of 2022. Then we have 2 deadlines, as I said, because you'll remember I said that there were 2 evaluation stages. So for the short proposal, we're looking at the end of September 2022. And then we want the full proposal, which you'll recall is prepared by the winning applicant consortium and the predefined industry consortium who have come together to form the final applicant consortia. That's the end of February 2023. We have the same criteria in relation to the independent legal entities, but we've put it here just to remind everyone. And then just to kind of differentiate between the 2-stage and the 1-stage, or the single stage, when you're putting in the short proposal for the applicant consortia at the first stage of the 2-stage call, the short proposal should be 20 pages. And then for the second part, for the full proposal, just like we have at the single stage, the full proposal should be 50 pages. So we're maintaining consistency across the calls in relation to the length of the proposal. And then as we have here, I mean, I've said this a couple of times, but we put the bullet point in to remind everyone, the first ranked applicant consortium, whoever wins the first stage evaluation, then they go on, they meet with the predefined industry consortium, and then together they prepare the full proposal for the stage 2 evaluation. So this should be clear. In relation to the topics here, so again, we need the clinical studies annex. This is clear. I'll remind everyone that the contribution is indicative. We also have the possibility for hearings if clarification is actually needed, and of course people will get notice of that. The plan for dissemination, exploitation, and communication activities is similarly needed as it is in the single stage. And then just we put this in as an underline at the bottom just for everyone to keep in mind. Contacts, discussions about a given topic between potential applicant consortia and members of the predefined industry consortium are prohibited during the procedure. So as I said, it will be clear from the topic text who the predefined industry consortia are. If you're in an applicant consortium, you should not be contacting these parties prior to the first stage evaluation and during the first stage evaluation. If you have questions in relation to the topic text, in relation to legal interpretation, please contact the IHI office. Use the InfoDesk facility, and we'll be able to give appropriate responses in that regard. In relation to information to the applicants, so we have information on the outcome of the evaluation. The time frame should be 5 months from the submission deadline at the single stage, and then we're looking at 8 months from the submission deadline from when we will actually have the grant agreement signed. Now, you'll remember, as I said, the grant agreement is signed between the coordinator and the IHI office. So we'll get that done within 8 months, and then there's 30 days after the signature of the grant agreement for the rest of the participants to sign up via the recession form. We'll flag this a bit later on, but I'll insert it here just to give everyone some context. If you're not signing the accession form, you are not actually part of the grant. You're not part of the project. So it is absolutely essential that we get these things done within 30 days from the signature of the grant agreement. And then we're saying for 2-stage calls, the applicants will be informed of the results of the first stage at the latest 6 weeks before the deadline for the second stage submission. So there will be plenty of time to reorganize. Right, so that's some general principles again. Now we're going to go into the entities eligible to participate. Now, the first thing that we point out here, and this is absolutely essential, and just speaking from my personal experience as a lawyer, we get a lot of questions on this, and we also always have to clarify there is a difference between someone who is eligible to participate and someone who is eligible for funding. So we've laid this out quite starkly in this slide, and we're basically saying that any legal entity, regardless of its place of establishment, which is carrying out relevant work, can be part of an applicant consortium. But that doesn't mean that everyone is eligible for funding, and we're going to develop this point more comprehensively in the following slides. But I think if we establish that and we all internalize that concept going forward, then all of the rest of the rules in relation to eligibility for funding and where the participant is coming from and the basis under which they can engage, all of this makes sense. So then for those entities that are eligible to participate, we basically say the legal entity, regardless of its place of establishment, including legal entities from non-associated third countries. And you'll recall that I said there is a defined list of who the associated countries are. So we're basically saying that even if you're not on that list, as long as if you're a third country outside, you can still participate, that's fine. And then for a legal entity, because we get quite a few questions on this, we basically say it's any natural or legal person created and recognized as such under national law, EU law, or international law, which has legal personality and may be able to exercise rights and obligations. So that's quite clear. And then we also have beneficiaries and affiliated entities, which is basically that's basically the types of participants that we're talking about. In relation to the restrictive measures, this is something that we're going to introduce here because it's something which is obviously very topical, but will obviously affect the projects that we're giving as well. So this is we're saying that given the situation in the Ukraine and the involvement of Belarus in the Ukraine crisis, we're basically saying that legal entities established in Russia, Belarus, or in non-government controlled territories of the Ukraine are not eligible to participate in any capacity. Beneficiaries, affiliated entities, associated partners, third parties, etc., subcontractors, the whole thing. So, and again, I'm just going to emphasize, we're not talking about the fact that they won't be eligible for funding. What we're saying is that they are not eligible to participate, full stop. So that's obviously a qualifier on my previous comment, which is saying generally everyone is able to participate. Okay, so then if we move on to consortium composition, this slide, it actually just restates what I've emphasized a couple of times earlier, but again, we want it to kind of be internalized. So we're saying we need 3 independent legal entities established in a different member state or associated country, but we definitely need one of those legal entities grounded or established in a member state. So 3 entities from 3 different associated countries isn't going to work. And this is something that we will of course look at, and it's an essentiality. Then, and now we've talked about participation. We've talked about generally everybody can participate. We've introduced the nuance in relation to the current conflict in the Ukraine. Now we're talking about once we pass the participation bar, then who's eligible for funding. This situation, there's a couple of different interactions here based upon the type of entity and also the kind of call that we're talking about as well. You'll recall a few slides back that I said that depending upon whether you have a single stage or a 2-stage call, that will have implications that kind of ripple throughout the process. It's very important here in relation to funding. So I'll go through this in a bit of detail, but I'll just remind everyone, if they're still not sure, we'll be able to refer them to certain documents at the end of the slides. And the legal team and the InfoDesk team is always happy to provide additional information on this afterwards. It should be fine. So in relation to eligibility for funding and the common principle is, as I said, any legal entity established in a member state, associated country, or low and middle income companies are generally eligible, subject to what we're going to go into. And there are common principles for both single and 2-stage calls. Now, this is quite a busy slide, so I'm not going to actually read through it, but what I will do is emphasize the key points. So if we say that the legal entity established in the member state, associated country, or low and middle income are generally available for funding, and we see here at the bottom of that first green box, low and middle income countries, like the associated countries, the low and middle income countries is actually an enumerated list. It's an identified list, so that removes any vagueness, and we're basically, that can be found in the Horizon Europe Program Guide. So if you go online, track down the Horizon Europe Program Guide, you'll actually see the enumerated list, and you'll be able to identify who the low and middle income countries are. And in a similar way, the associated countries, those countries who are associated to Horizon Europe, are identified as well, subject to a couple of points that I'm going to come to a bit lower down. And then just some general points. We're saying the member states, of course, are eligible for fund. The entities from the member states are eligible for funding, including their outermost regions. OCTs, clearly. Now, countries that are not in the identified EU can still be eligible for funding, subject to the following. So we're basically saying, as I said, if you're an associated country, you are fine, and that's an identified list. There's a couple of interesting points here which I will cover, which is for our purposes, as I'm sure everyone on the call knows, negotiations are ongoing between the UK and the EU as to the UK's participation in the Horizon Europe program. And there was some preliminary agreements signed, as we know, some time ago. The approach that we are taking is that the UK applicants are treated as currently as if the UK is an associated country. So in terms of admissibility and eligibility, we're treating them as they're already in the family. Now, this is going to continue right up to next year when we're actually signing the grant agreements, because what is being done is time is being allowed for these discussions to actually be finalized. But if we get to the point of grant agreement signature and those agreements haven't been concluded, or indeed the UK has decided that they don't want to participate, then that we'll have to revise the situation there. So because clearly legally they won't be an associated country and they will actually be a third country. So this is something which applicant consortia are going to have to very seriously consider, and you're going to have redundancies built into your plan to take account of this, because at the moment the final outcome of the discussions with the UK is it's not clear to anyone. So this is something that we need to think about. And then you can see we've contrasted this with 2 third countries that we know are not going to participate in Horizon Europe and therefore are not going to be regarded as associated countries. And that is Switzerland, who are not covered by any current transitional arrangement, and Liechtenstein, who don't intend to associate to Horizon Europe. For those of you who are familiar with H2020 and IMI2, you'll recall that Switzerland were initially associated and then they weren't, and then they came back for part of it. Our opening position as regards Switzerland for IHI is that they are a third country, they're not an associated country, and if this changes, obviously we will everyone will know. And then the last legal entity that we would say are eligible for funding, as I said, is the low and middle income countries, and they're identified in the Horizon Europe program guide. And then we have in relation to those third countries, this is we saw this a bit in IMI2 and it will continue into IHI, even if we have a legal entity coming into a consortium. Initially, the position is because they are coming from a third country, they are not eligible for funding. However, if they are bringing something absolutely essential to the consortium, it is possible that that legal entity from the third country can receive funding. IHI is not going to make this determination. Who will make this determination are basically the experts who were involved in the evaluation of the proposal. So essentially what needs to be done is that in the proposal, the planned participation of this third country legal entity needs to be laid out, and the reasons why they're bringing in something spectacular, why they need to be in the actual project, why they should receive funding, and then this will be evaluated. And it's possible that under these exceptional circumstances, funding may be extended. More information, of course, we can provide on this separately or bilaterally. But the key point is that it is possible, providing they're bringing something which just can't be secured in the EU, and they're bringing something really, really useful to the project. So that's the first part of those funding rules. And then in relation to the difference in the calls, in relation to the eligibility for funding and the single stage calls, we're basically saying that, I mean, it's very, very wide for the single stage calls who can actually receive funding. So we're basically saying that the usual nonprofit organizations, academics, regulators, NGOs, patients organizations, all of those who you would expect to receive funding can receive funding. But technically under the rules, and we're going to develop this a bit later on, also for profit organizations, and this includes both SMEs and larger companies, companies that would be substantially larger than the normal conventional SMEs, they can conceivably under IHI receive funding as well. Now I'm going to develop that a bit later, but what's important to keep in mind for the purposes of single stage calls is that there's a great deal of latitude in the single stage call as to who can receive funding. It's much and that gives maximum flexibility to the applicant consortia, because remember the applicant consortia gets one chance to do the evaluation, to build a good proposal in relation to the call topic text. So this gives them a lot of flexibility in relation to the resources that they want to bring to bear to address the challenges that are laid out in the call topic text. And then the two-stage call, this is a bit different. So what I would say is concentrate primarily on the top, which basically states that, again, we have exactly the same. The non-profit organizations are, of course, eligible for funding. The distinction here is, you'll remember I said for one stage or for single stage, all sorts of companies can receive funding, but here it's very clear. We basically say that SMEs and larger enterprises with an annual turnover of less than 500 million euros can receive funding. So as a point of principle, if your annual turnover is 501 million, then I'm afraid you're out. But if you're up to 500 million, then you can actually receive funding in a two-stage call under IHI. And as we've identified here underneath, we're basically saying that it's the converse of this is that there are some entities which are very clearly not eligible for funding. Those members of the predefined industry consortium are clearly not going to receive funding under a two-stage call because they're bringing resources to the actual project. Those resources are identified in the call topic text under the indicative budget. It's very, very clear that they're contributing, therefore they're not receiving funding under it. When we have this two-stage call and when we have the merging of the applicant consortia and the predefined industry consortia, and we have the final version of the actual consortium, under that, essentially the applicant consortia, the non-profit organizations, the universities, the research institutes, they'll be the ones receiving funding, and the pre-identified industry consortium will be the ones bringing resources to the actual project. And then the second point here I have is I'm just kind of elaborating on the point I made in relation to if you're over 500 million, then you're not eligible. And we've inserted an additional bullet point here, which is when we talk about the turnover of 500 million, that's not just your immediate company. If you're part of a larger group, and the larger group is bringing in 500 million or more, then that is taken into account. And we have quite a detailed template and work process to establish those figures that are submitted to show whether you qualify for this or not. Right, funding rules. So, as we said, Ihijuu, it's a public-private partnership, and the actions are normally co-funded. So this is kind of encapsulating some broad concepts which I've already touched on. But what we're saying is that the Ihi funding primarily supports the participation in the projects, as we referred previously, to the non-profit organizations like universities, ORIs, patient organizations, SMEs, as long as they fall below the 500 million. Larger companies can also at the single stage receive funding. And then we also basically have, as I said, these the private members, including COSIR, FPA, Europa Bio, MedTech, and the Ihijuu contributing partners. And you remember from a previous slide, the contributing partners for Ihijuu, they are what the associated partners were in IMI2. They have an obligation to basically contribute to Ihi projects, and that's agreed. But collectively, when you're applying to an Ihi project, there is an obligation there for the consortium to ensure that 45% of the sum total of the project eligible costs plus in-kind contributions is going to be contributed. So what that essentially means is that when the applicant consortia is forming, they are going to ensure before project launch that 45% of the total cost is reflected in-kind. And there is actually a declaration which the coordinator is actually going to sign, basically stating that they have agreed that they're capable of reaching this 45% threshold, and this is something that Ihi is going to be checking religiously. So because it's there on the legal basis, so it's something which we are obliged to pay a great deal of attention to. So this is why we have this underlined in this slide. Moving on then to our types of beneficiaries. So, as I said, for the two-stage calls, private members and contributing partners. Private members, again, just to remind everyone, we're essentially talking about COSIR, FPA, MedTech, Europa Bio, and the contributing partners. Those are the philanthropic organizations who were the associated partners under IMI2. So just in case you're not familiar with this, I'm thinking in terms of those large funders such as the Wellcome Trust, such as Bill and Melinda Gates Foundation, such as Simon Foundation. And generally what they bring is in-kind of financial contribution, which is why we're identifying them here. So for the two-stage calls, we have these pre-identified private members and contributing partners. They're the main drivers of the topic definition. They identify their own in-kind contributions, what they're actually going to bring. We set this out in the topic text so everyone knows what the predefined industry consortium is bringing, and it's clear there from the start the resources that industry is bringing to the actual project. And as we mentioned in the previous slide, if you're part of the pre-identified industry consortium, you are not eligible for Ihi funding. You're contributing, you're not receiving. If you're not pre-identified, if you're not part of that pre-identified group, then theoretically you can come in as a part of the applicant consortium. You're not involved in the topic definition. You could join afterwards, strictly speaking, as an amendment. That's fine, but you can theoretically be eligible for funding if you meet the other criteria, and that's the important distinction there for the two-stage. In relation to, and I've actually covered this already, but just to keep everyone on track. So private member, as I said, is that any legal entity established under public or private law. including constituents and or affiliates that is a member of one of the industry organizations, and the industry organizations we're talking about FPA, COSIR, Europa Bio, etc. Constituent. Now, when we talk about the private member, we always talk about the private member and or their constituent entities and possibly their affiliated entities. So the constituent entity definition we're using here is essentially from the legal basis, but if I can give an example of what a constituent entity is, if you have a pharmaceutical company which is a member of FPA, and FPA is the private member of Ihijuu, then if you have a specific pharmaceutical company who is a member of FPA, or yes, FPA, then they are regarded as a constituent entity. So the language, it's a bit convoluted, but it's actually it's workable. And that's important. The reason why these classifications are introduced is because it reflects the mechanics that can actually work in the actual grant. And then an affiliated entity is different again. It basically means it's another company or another legal entity that has a capital or a legal link with a beneficiary in a project. So for those IMI2 veterans or those Horizon 2020 veterans, affiliated entity is the new term for what we did call a linked third party. The language, if you recall linked third parties in IMI2, the key criteria was a capital or legal link. So they have literally grafted the new name affiliated entity onto what was a linked third party, and they've introduced some additional language. So the key point is a company which is linked to a beneficiary with a capital or legal link. And examples of a capital or legal link, I think the best example we usually have is a collaboration agreement, which predates and it exceeds the length of the particular project that they want to get involved in. For further information on this, I'm going to talk about this later on, but if this idea of the affiliated entity and this capital or legal link is a bit nebulous, or you want some examples, the Annotated Model Grant Agreement, which is available online, I think the latest version is December 2021, has specific examples on this, and it's actually quite useful. So, and I will be recommending that everyone who is on this call downloads the Annotated Model Grant Agreement and has a look and keeps it with them for the entire process for their grant application, and the grant execution afterwards, because it's extremely useful for understanding some of these concepts. So that's our affiliated entity, and then lastly we have contributing partner. And as I've said this a couple of times, think philanthropic organizations and funders. They're not private members. They're not part of the organizations who are incorporated with IHI. They're bringing in kind to projects. Technically speaking, they will be beneficiaries themselves if they're getting involved in an IMI project or IHI project, but they participate in the consortium as well, and they bring in kind or financial contributions. Now, there's one point here that we've received an awful lot of questions on in relation to contributing partners, so I'll cover it here. I'll refer to it again later on, but just so we know, whereas private members can contribute in kind and financial contributions and in kind towards additional activities, it is very clear from the legal basis, I think it's Article 11, Subarticle 5, contributing partners may not contribute in kind to additional activities. And that includes for the purposes of the 45% assessment that I referred to a couple of slides ago and the self-declaration. So this needs to be very clearly understood. If you have a contributing partner in your applicant consortium, or if you anticipate a contributing partner getting involved in your consortium at some stage, for instance, if they're identified in taking place in a two-stage call, I think we already have one suggested for one of the call 2 topics. It's important to remember that they won't be able to contribute in kind towards additional activities, and we can develop that a bit later on. Right, industry contributions. So this is quite a busy slide. I'll try and encapsulate it efficiently. So in relation to the in-kind, I was talking there about in-kind to additional activities. We essentially have 2 different types of in-kind here. We have in-kind for operational activities, and we have in-kind for additional activities. Now, they're actually quite different species. Because in terms of where they originate from, how they're activated, and when they can actually be applied. So for ECOP, for in-kind, we basically say eligible costs incurred in implementing the action. I think if you're familiar with previous funding frameworks, this will be obvious. It's basically what's happening in the actual project. And like in IMI2, we can have ECOP, in-kind for operational activities, coming from non-EU as well. And again, we have caps in relation to that, both at a program and at a project level. We might develop those a bit later on. The difference here is that we now have this new concept for IHI, which is in-kind to additional activities. And this is calls for implementing additional activities which are not in the project. So the additional activities, for instance, won't be identified in the DOA, the description of action, or Annex 1. But it's something which can be useful to the program and something which is project specific. So we've got some examples here: dissemination, sustainability, or exploitation of IHI JU project results. Now, just to head off an inevitable question, because we're talking here about dissemination of results, for example, still remains very much an obligation of a project. So ICOP will need to be directed, or resources will need to be directed towards dissemination, sustainability, and exploitation of IHI project results. But EKAA, in-kind for additional activities, could be as well used in a supplementary fashion to further spread the results or contribute towards their dissemination and sustainability. I think that's perfectly valid. And what's really interesting about EKAA as well is that, by very definition, the ECOP, the in-kind for operational activities, that's going to happen within the time frame of the actual project. But for EKAA, we can actually have EKAA being contributed up to 2 years after the end of the project. And I think then again, it's very, very useful for the purposes of dissemination, sustainability, or exploitation. So I think if you keep these main bullet points in mind, then I think it becomes maybe a bit less nebulous and a bit less problematic. ECOP in the project, by the project beneficiaries, for the DOA, for actions laid out in the DOA. EKAA, something outside, not being done in the project, but project relevant, program relevant, and after the end of the project. And then the last type of contribution we have is the financial contribution, and this is usually cash contributions by either the private industry members. And I remember we said that private industry members, they can have constituent or affiliated entities. That's just, the pharmaceutical company that's a member of the larger group, or contributing partners. And based on our IMI2 experience, usually when we have these very, very large funders or philanthropic organizations coming into projects in our area, generally their main contribution, or a very, very substantial part of their contribution, is a financial contribution, and they do actually transfer cash to specific beneficiaries to further or support work that's being done on the project. So again, if you're anticipating a contributing partner becoming involved at any stage, this is of particular interest to you. And then our contribution types. I mean, this is essentially a nice, neat graphic to summarize what we were talking about a moment ago. So it kind of visualizes some of the complexities. So as we said, ECOP, which is happening in relation to operational activities, this is being contributed by private members and contributing partners. This is fine. Financial contributions, that's coming again from private members and contributing partners. This is clear. And then this is where it gets a little bit complicated, and this is why we felt it was really important to visualize in-kind contributions to additional activities. They're coming from private members, yes, but they're not coming from contributing partners. And that's, as I said, that's rooted in the legal basis. So there is a distinction there. And then we just have it in bold underneath what's confirmed in that table. So this is clear. Now, I think about 6 slides back, I was talking about this 45% eligibility criterion. So we have some additional language here. I think the key point is for this slide is to internalize 2 things. One, as I said, when you're coming with your project, with your consortium, IHI is basically going to look and scrutinize to make sure that this 45% of in-kind contribution of the total costs has been calculated and is understood, and there is a declaration that the project coordinator is going to make, which basically states that yes, we can satisfy this 45% criteria. Now we have it in red underneath just to make sure that everyone understands. If the 45% industry contribution is not secured collectively by the industry consortium participants, the proposal will be declared ineligible and therefore will not be evaluated. So this is very clear. We need to have this in place very early on. And then, as I said a couple of times, the IHI office is actually going to verify those 45% contributions prior to GA signature. So this is something that should be taken very, very seriously right from the start. In relation to the funding rates itself, I think this is understood, but we'll just revisit the point anyway. So we have one single funding rate per project. It's 100% for all beneficiaries in all activities, and we have the same indirect flat rate 25% as we did in IMI2 and Horizon 2020. So that actually hasn't changed, and there's no specificities and there's no complications in relation to the funding rate. At least in relation to the funding rate, everything is straightforward and clear. This is a table that we've produced, which I'm not going to go into because it will be here for quite a while, but I would make a couple of points in relation to it. As you can see down the left-hand side, we have these various categories of participant. We have the beneficiaries themselves who are signing the grant agreement. Then we have the affiliated entities who, as I said, they're like linked to third parties from IMI2, and there's a legal link between them and the beneficiary. So the affiliated entities, if we're satisfied that they have this legal or capital link to a project beneficiary, then the natural outcome of this is that the affiliated entity are then actually part of the grant agreement. They're identified in the tool, the electronic tool, under the beneficiary they are linked to, and they're referred to in Annex 1, which is the description of action, and their figures are reflected in Annex 2. So it is, what will happen here is that generally, with some exceptions, if an affiliated entity wants to join a project and they're saying, look, we are linked to this beneficiary, the first thing IHI office will say is, this is fine, but we want documentary evidence that you are in fact in possession of a legal or capital link to the specific beneficiary. And this is something that we did under IMI2 as well. And I think that usually, as I said a few slides ago, it's in the form of a collaboration agreement. There are other possibilities as well, and we want to make sure that this link hasn't been established just for the purposes of addressing a particular project, so there's time constraints as well, but it's usually a quite straightforward process. Then we have the associated partners underneath. Now, just to avoid confusion, as I said, under IMI2, we had associated partners who were these external funders and philanthropic organizations like Wellcome Trust, like Gates, etc. The language in Horizon Europe has changed, and associated partners are essentially now, I'd call them loosely international legal entities which are loosely associated to the grant. They don't sign the grant agreement. They're contributing to the project, but in quite a loose way. They're basically the successor to what we would have called international partners, which was covered by Article 14A under the Horizon 2020 and the IMI2 grant agreement. So we're including them here. It is possible they could actually get involved. So we've included them in the table. Speaking personal experience, I wouldn't imagine a huge amount of participation on this point, but we've put them in anywhere for completeness. Then we have third parties contributing to the project, and everyone's familiar with these. These are not signing the grant agreement. They're not a linked third party, but they are providing support to the project. They're usually providing in kind, either free of charge or against payment. Then we have subcontractors. I think a subcontract is clearly understood by everyone. It's essentially they're completely separate from the project. They're normally their own legal entity. They are engaging. They're contributing to. They're performing project tasks, but on the basis that they're making a profit. They're making a profit, and their terms of engagement are slightly different than the third parties before. And the details of this subcontract needs to be explained in Annex 1, which is a description of action. And of course, these figures need to be scrutinized. And then lastly, we have third parties receiving financial support. This is possible again under IHI. It won't be activated calls 1 or 2, but it's something that may actually be activated going forward. So if we look at these entities on the left, for the purposes of this table, I'm not going to go through the intervening categories or fields because I've already mentioned some of them. But in relation to the annotated model grant agreement I mentioned a few slides ago, we've listed here the relevant GA article, the relevant grant agreement article that maps to these various types of participant, beneficiaries, affiliated entities, third parties, etc. So if you have a question, is this a subcontract? Is this just a third party providing in kind? If you have the AGA and you are familiar with the document, the examples and the case studies and the best practice notes in the AGA will give you sufficient information and confidence to be able to categorize these things yourselves, and will give clarity as to how all these moving parts interact. But I'll reiterate, if you have a question, please send it to the info desk when you're obviously preparing this work, and the legal team will be happy to assist on any matters of interpretation. But as I said, this time around the AGA is particularly good, and they've put in quite a lot of examples, and I think these kind of things are quite clearly defined. There's been some paradigm changes from Horizon 2020 and IMI 2, but I think that the key concepts haven't changed too much. So that's our types of participants and cost eligibility rules. So we have the Ipr section next. I'm just looking at Catherine here. What we could do is, if there's some relevant questions, maybe Plivius and I could address the questions here, if there's a few which are there.
Yeah, so partly just to give you a bit of a breather, Desmond, because you've been talking non-stop for close to an hour now. And obviously people have sent some questions, many of which I think have been addressed in your presentation, actually. And yeah, so I'll add as well, we also have online Plivius Ajiangu, who is part of the scientific operations team. So, I mean, we have quite a lot of questions about, obviously you need to identify industry partners and for the single stage calls, and how can you do that? And I mean, one thing I will say here already is, of course, next Tuesday we have a brokerage event, which is online and on site in Brussels, although I think the on-site places are pretty much full. So yeah, I'm getting a cutting signal there from my colleague Tom, who's managing the event. So there are no on-site places available anymore, but there are plenty of places available online. We have over 1,100 people registered. That the whole point of that event is really to help people find partners, including, of course, partners who are going to contribute to the projects for that 45%, which Desmond just presented. And of course, there are also the core topic webinars, which start next Wednesday. We have one webinar for each topic, and there as well, when you sign up, you're asked if you want to share your information for networking purposes. So that's another place. Otherwise, all the general networking information, use your own contacts, use other events, use social media, and you do the legwork you need to find those partners. It is a lot of work. We do recognize that. We're trying to do what we can to help you, but in the end as well, it is a competitive call. So we obviously can't help individual people. So going through the questions, so we have a question on the how can you identify the industry partners. I'm just going to scroll down quite carefully because there are quite a lot. How can you see who is part of the pre-identified industry consortium per call? Well, for the two-stage topics, it will be in the draft topic texts. The versions that are online now, the industry consortium is not in there, but it will be in there in the final topic text. But again, as Desmond said, you should not be contacting those people for the two-stage calls. So that's really just for your information. Another question here, which either Polivios, if you want to unmute yourself, you can take this, or Desmond. In two-stage calls for proposals, is the coordinator of the project always from the industry consortium?
No. Now, I think that's an excellent question, and I think it's a good question because it talks about the consortium dynamics. What I would say is that IHI, we do not mandate whether the consortium should be from the initial applicant consortium or from the predefined industry consortium. We don't have a hand in that at all. What I would say is that in our experience from IMI 2, I think it's quite frequent that the coordinator is in fact from the applicant consortium. So there is a well-established precedent that the coordinator is from it's usually one of the universities, or it's the applicant consortium that does it, and then the predefined industry comes in and kind of adds to it. But sometimes they may take a project management role in relation to some of the scientific activities. But I think the short answer I can actually give you is no. Very clearly no. The coordinator is not always from the industry consortium.
Okay.
And Desmond, maybe here it's important to mention that the coordinator should be financially viable in order to undertake this task. So in order to avoid any surprises, if the proposal will be selected for funding during the grant preparation process, it's important that this entity, if it's not a public one, of course, has to do this financial viability check to ensure that they are financially viable in order to ensure a smooth implementation of the grant preparation, and instead of looking for a new participant to undertake the coordinator role in the last minute. So it's important to be financially viable in order to go and sign the grant agreement.
Yeah, thanks, Plivis. That is actually a brilliant practical point, and it's something that we have experienced in the past. So I think that's absolutely, again, I think this is one of the key points that people need to internalize and take away from this actual webinar. If we have a coordinator there, they have to be financially viable. Obviously, we're going to look at it, and this can derail gap preparation and that kind of thing if we have a weak coordinator. So I think that's a brilliant point to actually add.
Okay, and is there a fixed number of projects to be funded? I mean, I think for the two-stage calls, it's as it was in IMI, there will be one project. Yeah. Whereas for some of the single-stage topics, there could be more than one. It will be a little bit like what we had, I think, for some of the Ebola and the COVID calls in IMI, where there was a ranking list and those that were above threshold and within the total budget envelope got funded. But I think there will be more information in the topic text as well on that.
Of course, in the topic text, we will have the indicative funding per proposal, meaning that applicants, they should put an indicative, the amount that they're planning to build the proposal with. So they're based on the availability of the budget and the ranking, like you said, we'll establish the list, and then based on the available budget, we'll proceed with the funding. However, of course, the budget built with the proposal should be linked with the tasks and the objectives of the topic. So it's not only just putting the budget, it should be linked with the objectives of the topic. So from that point of view, we'll see if we will manage to fund hopefully more than one proposal. But this, like we said, it will be based on the available funding.
Okay. And the next question, who predefines the industry consortium? I'm assuming this is more with reference to the two-stage topics.
Yeah, I mean, I think here we're talking about the predefined industry consortium, which is identified in the topic text. I think what needs to be clarified here is when we talk about the pre-identified industry consortium, this isn't the IHI office saying we need this company and this company and this company, and they're going to bring resources A, B, and C. I think this is a self-organizing principle on behalf of industry themselves, and they say, look, this is a topic that we're actually interested in. These are the private members who are interested in contributing to it, and this is what they can actually bring. So I think the short answer here is not the IHI office and industry themselves.
Okay, next question. Will there be specific funding, quotas and partitions allocated to the single and two-stage calls? Yes, there will be specific budgets per call. And again, it will be in the call texts once they're published. The June call is open to mid-sized companies or only to SMEs? As Desmond said, yes, it is open to mid-sized. It's up to 500 million turnover with the caveats about links
in relation to the caveats, yes.
But basically, yes.
What I would say is in relation to the June call, if you're coming in, if you're under, and you remember I'll talk about not just your legal entity if you're part of a larger group, but if you're hitting this sub 500 million euro threshold, then whether it's call 1 or call 2, the options are there eligible for you to receive funding. If you're larger than that, then obviously your options are better in terms of call 1.
Okay. And then in stage 2 of the two-stage calls, obviously, is there only one applicant consortium? Well, at that stage, it's really one full consortium that goes forward. And the evaluation then, it still has to meet certain criteria. So it is still a full and serious evaluation. And then we have some questions on Desmond's favorite subject, the 45% issue. So can you explain that at least 45% of each project's budget has to come from industry partner or contributing partner contributions, and does this mean that applicants have to find an industrial partner that provides this 45%?
I mean, yeah, I mean, I think you've summed it up quite well there. Essentially, for instance, if I'm responding to a stage 1 call, as I said, if it's a stage 1 call, then you don't have this predefined industry consortium coming in at stage 2. So what you're doing is you're basically saying this is our applicant consortia, and you go out and you bring in industry, and it's understood that in between yourselves, but primarily from industry is going to contribute this 45%. So yes, I think what I would say in relation to the 45% is to try and clarify from everyone, it's expected that the 45% contribution is going to come from industry, but it's everyone's responsibility because it affects the viability of the applicant consortia. So it has to be considered by everyone. And, IHI office, our view is going to be, has that consortia signed the declaration, that the coordinator does to say that they're going to hit the 45%. And then we will scrutinize it and say, has that consortium secured 45%? Can we see the 45% contribution there? And that's why on the slides I was talking about this, I said this is something that the consortium needs to consider right from the very start.
Desmond, maybe here one message for the potential applicants. This is a public-private partnership.
Yeah.
So this is a model that we are working with private members, with our industry associations, and also with contributing partners. Mm-hmm. So the topics are targeting also this nature of bringing together the public and the private sector. So from that perspective, if applicants cannot secure 45% coming from the private members and or contributing partners, then the topic is not for these applicants.
Yeah.
This is a really strong message to be spread around, that the 45% is an eligibility criterion. The proposals will not be evaluated if the 45% is not secured. And this 45%, like Desmond said, will be verified, but also the membership of the participants that providing the 45 will be verified before the grant agreement signature. So from that perspective, it's important that these topics are targeting the public and the private sector.
Okay, I think in the interest of speed, there are some questions which I think Desmond has answered, like on the question of whether a SME in the US can participate and be eligible for funding. I think that was answered. There are also questions about the role of the UK and Switzerland, which have been answered. There is one question here: in Horizon Europe, are developing countries automatically eligible? I think you touched on it, but
developing countries. I mean, I don't want to use inappropriate language or make inappropriate comparisons, but what I would say is, if a developing country, this is where we need to be careful, also qualifies as a lower or medium income country and is identified as such in the Horizon Europe program guide, this document that I talked about, then yes, they would qualify as funding under that classification. So developing country, we're not addressing in terms of who can receive funding, but it's possible they could fall under another category. I think it's the best way.
There is a list.
Yes.
Speaking of...
Yes, Catherine, also for the UK was a question that all the Q&A of the European Commission on the UK is applicable also for IHI.
Yeah.
So if they have more information, they will, applicants can have also more information there, but it's applicable also to our cause.
Okay. And there was another question related to this. I presume also on the Horizon Europe portal and things, we can get a link to the list of the member states and associated countries, because that's also an evolving list as well. So it's all on there as well. So yes, that is online. Just scrolling down, there were a few people who had some small issues. I'm just trying to make sure I don't miss anything. So someone has shared as well for the case of organisations in Switzerland. One of the participants has kindly shared in the chat a link to how they can get national Swiss funding if they are successful in getting funding from us. So thank you very much to that person for that one. So there's a question here. In the situation of a two-stage call, if there is a not-for-profit research entity but participated in majority by a big company, what would their eligibility be? So this question here.
So wait, we're talking about a two-stage call. We have a non-profit RI but participated in majority by. All right, so I think So I think what we're talking about here is a non-profit which has a majority ownership by a for-profit company. I think that's what we're talking about. So, I mean, because they're a non-for-profit, then we wouldn't go to the SME assessment and start looking at whether they qualify for the 500 million threshold, because they would be, if what I would say is if they're classified clearly as non-for-profit, then I think they would be eligible for funding. But to be honest, I would have to check this internally with our own team to make sure that everyone was behind this interpretation. That's actually quite an interesting question, because as I said, out of the gate, non-for-profits, they're eligible for funding. This is clear. It's just in terms of this larger participation, if that large participation, if we have a majority share ownership from a actual for-profit entity, that calls into question then, to be honest, do they actually need funding if they have this large entity behind them? So it's Angel, is that the name that I actually saw? What I would suggest is, if you want to discuss this further, please just send us a question to InfoDesk, and I'd be happy to engage with you, and we can give you a detailed answer on this when I've had the chance to discuss with the wider team.
I mean, sometimes these things, it's the question of a very specific organization.
Yeah, so there's a couple of nuances here, but that's actually quite a fascinating question.
You've made this.
Desmond, sorry. Desmond.
No.
Hey, Desmond.
Domenico.
Hello. If I just arrived, sorry. If I can complement what you just said, it's totally right. And what we will need to refer to the control. So either it could be controlling the decision to be taken by the participated entity, non-profit entity, or in the control of the shareholder control.
Yeah,
I think here, I'm trying to, in the interest of time, I think in this is, because this is quite a specific case, as Desmond said, send us an email. And as you can see as well, we do have some other lawyers online, just checking everything we're saying. So send us the specific situation you have.
But kudos for the question, because as you can see, you've got the entire legal team excited. So that's quite rare. So good job.
Okay, so the 45%, is it only in kind? It can also be financial contribution. Okay, great. Can a member from FPA participate in a consortium for single or two-stage calls? So for two-stage calls, they would normally be part of the predefined consortium. For single stage, yes. If it's relevant for the topic, they absolutely should be there.
Yeah, and we'll need them, potentially we'll need them for the in-kind anyway. So,
exactly. Someone is asking if we can define in detail ICA. We could spend a whole webinar, and in fact, the IHI staff yesterday had a whole webinar on in-kind. So I'm not going to go into detail here. What I will say is that my colleagues in the finance and legal and science teams have put together a very comprehensive guide to in-kind, including ICA, which is one of these lovely new acronyms we have, the in-kind contributions to additional activities, and it will be published on our website. So I would say, have a look at that, and then of course if you have questions, come back to us. So just a clarification question here, the 45%. So if the indicative budget of a project, I'm assuming budget of the project is 10 million euros, then IHI partners and of course contributing partners must contribute 45% of that. Is that on top of the 10 million, or is it of the 10 million? So I think this is a question of the definition of the budget. So I think if the total budget of the project is 10 million, 4.5 million has to come as in-kind million in total.
Catherine, if I may say here, the team also is preparing the guide for applicants. So whatever we discuss here today, all these will be reflected to this guide, and we will have also concrete examples of budget tables with all the type of contributions, how each participant, the type of participant is reacting, let's say, to this type of budget, and there will be very helpful to the potential applicants. We'll make it also, this guide, available very soon, so applicants will see from there with concrete example the budget and the type of participation.
Okay, thank you. So there is a lot more. This is obvious, these are our very first calls. There is a huge bunch of documentation that is going to hit the website in the next week or so, but certainly by the time of the call launch. So do take the time to read it. So moving on very quickly. So people are asking again about 45%, saying do research centres which are private non-profit institutions have to guarantee 45%?
Yeah, I mean, I think I cleared this in the question. Basically, I mean, they're not going to be providing, I presume, in kind to address the 45%. But if you are a non-profit and you're in a consortium, this is something you need to think about as well.
But I mean, again, the 45% is for the project, not
Yeah.
for individual participants. Because
Yeah.
I know that's a question we've had in the past. How would you categorize a public healthcare provider / public hospital?
I guess they're talking about whether they're eligible for funding. So out of the gate, I think we could say that unless there's something weird or unusual and they're in the EU,
Yeah.
I think they could qualify for funding.
Okay. And there's a note here from someone saying Swiss partners cannot be coordinators, but only partners. I
Yeah.
assume that's correct.
Yeah.
Okay, good. Thank you for sharing that advice.
I'm just seeing at the end, therefore it is cost neutral. In this respect, are Swiss institutions regarded as contributing partners?
Yeah, there is also that.
Yeah, that's interesting. So if the Swiss partner was contributing in kind, and basically you could go that route, but I don't think it would actually be necessary. I think it would be possible for the Swiss partner to basically participate, just not receive funding in the actual consortium.
Okay. And one, I think this might actually be a good place to pause and to allow Desmond to go back, because the next question looks a little bit like it's about ICAR and definitions of results.
Yeah, okay.
So I assume we're going to touch on that a little bit in the next section, and aware of the ticking clock.
Oh, I think that's time.
So I think we can crack on with the presentation.
Okay, I know everyone is super excited to get to the legal part, the detailed legal part in the IPR. Just with reference to what Catherine said, we could talk about EKA all day. We could, particularly the lawyers, talk about intellectual property all day. But what we've tried to do is boil the key concepts down to just a few slides, just for the purposes of this webinar. And then obviously when we talk about specific topics or we talk about specific projects, then the legal team will be providing more guidance on it. But look, I think we're going to do this about across 5 slides. We're going to talk about just the general concepts for IPR in relation to background, results, access rights. Then we prepared a slide to contrast IPR between IMI2 and Horizon and IHI, and then we're done. So I guarantee you before we start that this actually won't be too burdensome, and I apologize to the non-lawyers in the audience. So first things first, we're just identifying 3 terms here very clearly. As I said, if you're familiar with IMI2, much of this is going to be familiar already. So the 3 terms are background, results, and access rights. And basically, background is something which the participants are bringing to the actual project. Think of it as their contribution, small c contribution. So background can be any data, know-how, or information, whatever its form or nature, including any rights such as IP rights that is held by the beneficiaries before they accede to the grant agreement. You remember the accession is signed by each beneficiary within 30 days after the signature of the grant agreement, and that's how they join the project. And B, it's needed to implement the action or exploit the results. So the key point here is that when we get to the consortium negotiation stage, after the evaluation, when you guys are getting ready for grant agreement signature, there will be a consortium negotiation stage where all of these things are worked out for the consortium agreement. The consortium agreement, as most of you will know, is basically a separate document which is executed between just the participants themselves. IHI doesn't sign it. And it basically lays out the day-to-day practicalities of running an actual consortium. But in that consortium agreement, one of the annexes will basically list and identify all the background that the participants are bringing to the project and is going to be used in the project. And you'll have discussions about, is this relevant for the project? Is this needed? Who's bringing it? Under what terms? Et cetera, et cetera. So that's the background. The key point about the background is it's brought in at the start, it's identified, it's used, and it's generally used to generate the results, which I'm just about to come to. Then for results, now this is a little different from what we had under Horizon 2020 and IMI2, but and any of the IPR lawyers on the call will see this as soon as they see the definition. So basically, results are now defined as any tangible or intangible effect of the action, such as data, know-how, or information, whatever its form or nature, whether or not it can be protected, as well as any rights attached to it, including IPR. So the key point is, I think for the non-lawyers, you run the project, you carry out your work packages, you generate the result in the actual project, and whatever you're producing in the actual project is regarded as results. Without going into too much detail, we had before in IMI2 and Horizon 2020 this concept of, is it a result or is it side ground? And a result was basically anything which could be accurately forecast and was generally laid down in the DOA. And anything which was side ground was this idea that if it hadn't been anticipated and was completely unexpected, then this was side ground and different rules applied. But now in IHI, in line with Horizon Europe, we're basically saying that anything which comes out of the project, tangible or intangible, such as data, know-how, information, etc., is classified as a result, and then that has an effect on the access rights. So that's all I'm going to say for the purposes of the slide. In one way, it's easier because it's anything that comes out. You don't have these grades that we did in IMI2, but on the other hand, that's quite encompassing, so people need to think about that. And then the third point is access rights, and access rights is simply the permissions as to the terms under which one beneficiary or someone else can use either the background or results or both from an actual project which is held by another beneficiary. So just by way of example, if Catherine and I are in the same project and she brings some background to the actual project, if I want to use that background and I'm in a separate company or a separate academic institution, I need to basically exercise an access right so I can access her data and use it to generate my own results or do something else with it. So those are relatively straightforward and clearly defined terms. More detail and background, as I said, I've kind of covered this already, but we just put a slide in here to make sure so it's easy to access. As I said, any data, know-how, or information, including IPR, that's held by the beneficiaries before they acceded to the agreement and needed to implement the action. And this language is taken straight out of the legal basis. And as I said, there's the obligation there. We identify in a written agreement, which is normally the consortium agreement, what background is there. And the key point is, when we're talking about background, is this needed for the particular action? So it's self-explanatory that the background is going to vary from project to project. There's always a different background list to be negotiated for each project by each consortium. And then the ownership of the results. So in relation to when I said we're performing work in the actual project and we're generating the results, the very, very first general rule, and this affects everything else, it affects access rights, it affects downstream handling the results. If you generate a result in a project, you are the owner of that result at the first step. You generate it, you own it. You can do certain things, you can transfer ownership, et cetera, and we can talk about that afterwards. But the general rule and the touchstone for everything is, if I generate a result in an IHI project, I own it. If Catherine wants to do something with it, either she exercises an access right, or we do a transfer or something else. But you know, I'm confident in my security as the owner of that result. But I'm also recognizing, because I did this in an IHI project, that access rights are agreed with my fellow beneficiaries, so they can access these results if they need to. So this is clear. One case we always talk about when we talk about IP is the possibility of joint ownership. Now, the key point about joint ownership is that joint ownership in the legal basis for IMI and IHI is quite specific. It's not as simple as just two people produce a result and that's it. The example here is that, and the classification is that it's only a joint ownership if you look there at the two bullet points, the sub bullets, they've been generated by multiple beneficiaries, and it is not possible to establish the respective contribution of each beneficiary or separate them for the purposes of applying or obtaining protection. So that second bullet point might be kind of theoretically a bit nebulous. One of my colleagues came up with a truly excellent example, which I'll share here. If you had multiple beneficiaries and were joining, and together they built a table. Somebody works on the legs, somebody does the lamination, somebody does the joints. At the end of the day, it's not possible to separate that table for the purposes of protection, because you would be applying protection for the table. So that is a perfect example of a joint ownership situation. In that case, I think it's clear that, you know, they know that this is actually going to happen. So going down to the second bullet point, if you have a jointly generated result, a joint ownership agreement has to be concluded, which governs how the beneficiaries that own this joint result are going to handle the result. You know, is it going to be transferred afterwards? Who's going to take responsibility for it? Who's going to take responsibility for protection, dissemination, et cetera, et cetera. So this joint ownership agreement, this is outside the grant agreement. IHI doesn't see it. We just want to make sure that it's actually done. For perhaps the reassurance of everyone on the call, joint ownership situations, in our experience from IMI2, are relatively rare, but it's possible. So we always include a slide just to make sure that this is clearly understood. All right, obligations towards the results. So as I said, if I actually generate the result, I have a couple of obligations. I have to protect it, obviously, and I have to exploit it. This is understood as well. Obviously, I have to grant access rights to the other beneficiaries as well. This is all quite straightforward. Just the second paragraph, or the second main bullet point, obligation to exploit. As you can see here, I'm just going to draw attention to this because, you know, it is quite pertinent. If you are receiving EU funding, you must, up to 4 years after the end of the action, use your best efforts to make sure that whatever you've generated is actually exploited indirectly by another, even if it's indirectly by another entity, in particular through licensing or transfer. If you can't do that, if the results aren't exploited within 1 year after the end of the action, then you are obligated, again, if you're a beneficiary receiving funding, to use the Horizons results platform to find interested parties to exploit the result. So this, the HRP, the Horizon Results Platform, is a completely separate tool. It's easily accessible. It's going to be available for all beneficiaries, to not just IHI projects, but obviously the wider Horizon Europe program. And there's a lot of exciting stuff being fed into that. So that's just for reference. Obviously, this is a matter for further down the line, you know, several years when we have projects up and running, but we're flagging it now to make sure that, again, these are the key points that we want potential applicants thinking about right from the very start. And then access rights, as I said, if I generate a result and Catherine wants access to it, then in terms of IHI, and this is where there are some real differences from IMI2, basically access rights to background and results for implementing the action, you get it on a royalty-free basis. This is the same as we had under IMI2. But then for exploitation of results, it's basically on a fair and reasonable conditions. So those are fair and reasonable conditions to be negotiated between the beneficiaries themselves. This can also be further elaborated on in the Consortium Agreement. And in our experience, the beneficiaries are very good at deciding themselves what's fair and reasonable. Sometimes it can even be royalty-free. That's a discussion for the consortium. And then we've also put in some additional points here in relation to entities under the same control. This is clear. And then, as I've said here in red, additional access rights can always be agreed upon in the consortium agreement, and they frequently are. And in relation to the access rights, we may get a question for what we had under IMI2 for the third-party access rights for research use after the end of the project. I'll talk about that in an upcoming slide because there have been some changes there. All right, actually, this is the slide here. So IPR in IHI compared to IMI2, as I said, there are some changes. So whereas before, if you're familiar with IMI2, you'll remember that we kind of had our own quite good, unique to a certain extent, legal basis for IPR. Now we're just using the standard Horizon Europe rules. So as you can see, bullet point 2 here, we've basically said that the IHI rules are basically, you're going to the model grant agreement, you're looking at Article 16. Then we've got additional specific rules from Annex 5, which is also in the MGA, but it's towards the back. And I would just flag this for anybody. If you're going into Annex 5, there's a couple of points. There's the general Annex 5 Horizon Europe action part, which is relevant. But then even further down in the document, there is a very, very small but incredibly important section, which is basically Annex 5 specificities for actions carried out by the JUs. And then in that section, there's even another subsection which basically says IPR rules for actions to be carried out in Annex 5 by the JUs, specifically for IHI. So what I would say is that just be aware that looking at the MGA and looking at Article 16 isn't actually going to be enough. You need to dig into Annex 5. Obviously, this is going to be for the lawyers, but then they also need to look at Annex 5 in detail. And then where relevant, there could actually be applicable call conditions influencing this as well. Third bullet point, and this is important. IHI, under the legal basis, we maintain the right to object to transfers of ownership or exclusive licensing of results that are generated in the project. Now, this would primarily affect the transfer or exclusive licensing of project results outside of the EU. But at the moment, in the legal basis, it basically states, and again, it's in both the Single Basic Act and it's referred to in the MGA. Ihijuu can exercise a right to object both against those beneficiaries who have received funding and against those beneficiaries who have not received funding. And this is different from IMI2, because in IMI2, this just applied to beneficiaries who are receiving funding. But this is also an issue now for beneficiaries who are not receiving funding. So this is something that again, needs to be kind of thought about at the opening stages, whether you contemplate moving your results outside the EU, where they're going. This is something to consider. Next, in IHI, we have a dedicated specific results ownership list, which comes in as part of the final periodic report. And this will need to list all the results of the actual project and ownership of them, including joint ownership structures. So, I mean, I think this is actually, personally as a lawyer, I think this is actually quite a good idea, because it basically gives a very, very good summary of the IPR that's actually coming out of the project, where the ownership is actually vesting, and kind of allows us to do some interesting analysis on it. So I think that's useful. And then we also, as I said, we have the emphasis on exploitation and open science. So we have the open science dissemination model, affordable access provisions, which could impact your projects, which basically states that we need to have provision for the idea that downstream products or services derived from certain IHI products, the outcomes will be made available, accessible, and affordable to the general public. If you're in a project where these terms apply, I guarantee you will know about it, and it will be discussed extensively. And the IHI legal team, we've done a lot of work on this recently, and we are on standby to discuss this further with those specific consortia when those particular projects launch. I think this is going to be one of those ongoing issues that we're going to have discussions about in the next few years. And then lastly, as I said, unexploited project results can be matched with interested parties via the Horizon Results platform. We've already said that in the previous slide. So in relation to notable access changes to IMI2, from IMI2 to Ihijuu, access rights now, we don't have our own specific access rights. They're basically the Horizon Europe access rights. And I referred to this on the previous slide, so I'll mention it here. Under IMI2, we did have this interesting facility whereby after the end of a project, a third party could come along and request access to that project's results for research use, and possibly then the background needed to interpret those results. That facility doesn't exist anymore. So whereas before in IMI2, you had to make facility in the consortium agreement for these third-party access right requests after the end of the project, you don't need to consider it anymore. That's not part of the IHI program. So that can be reassuring for some of our participants. And then lastly, in red, and this is just, I mean, this should be clear, but just to make sure, project IPR specificities. As I said, we have the high-level rules in the grant agreement, and then the day-to-day handling of IP, you are laying that out in the consortium agreement after you've had those discussions. And that just makes everything quite clear and quite straightforward. Okay, so that's our IPR. I'm just looking at the time. So I'm just gonna go through this bit quite fast, but the information is relatively straightforward. So what we've done here is we've just taken a couple of screenshots in relation to what it will look like when you actually submit a proposal. So this is obviously the funding and tenders portal, and basically, as we've said there, you're putting in the additional information. To access the information, obviously you need the login account, you need the ECAS account, you'll need the PIC, which is the 9-digit personal identification number, and that's how you access the funding and tenders portal. In relation to the proposal, we've introduced some additional information here. So we have the full proposal template, we have the short proposal template. They're generally similar, but obviously there are some changes. So as you can see here in the short proposal template part A, we basically have general information, we have participants, and we have the budget, and they're slotted in, and you can update the information at any time. For the part B of the proposal template, then this is where we start talking about the evaluation criteria. So the evaluation criteria, as we probably know, it's excellence, impact, and quality and efficiency of the implementation. And for the short proposal, as I've mentioned a couple of times, the maximum page length is 20 pages. And the proposal obviously should respect that limit. I cannot emphasize enough, IHI, we have no discretion to basically read on after 20 pages if we think your proposal is particularly interesting or entertaining. The tool will limit it automatically at 20 pages and we won't be able to access it. So brevity is your friend here in terms of getting your key points across for the purposes of the evaluation. And then there will be some annexes, obviously. So the first main annex is in relation to the actual participants. I think that's self-explanatory. We lay out the participants that we have here. That's so the reporting obligations can be met. And even though it's not part of the proposal, it's not part of the evaluation by the independent experts, we need to have it there before you guys can actually finalize. So it basically lays out who the participants are, the kind of participants that they actually are, and it's useful for us. And then for the full proposal, so as I said, short proposal 20 pages, full proposal 50 pages. Part A of this, again, is generated in the IT system, so it's going to do a lot of the work for you. And then it's broken down into various template sections like general information, the project details. Then we have the participants, the gender equality plan, which is of course interesting, the budget, the ethics and security, and then other relevant points. And then for part B, we basically have, again, just like for the single stage, it basically talks about the evaluation criteria. Again, I emphasize 50 pages, full proposal, and we cannot read past that 50 pages. So you need to fit everything into your 50 pages. We can't go one line beyond. And then we've just put this together. It just identifies the various annexes to the proposal that you will have to basically think about. Some of them are compulsory, some of them are optional, but I think everyone should have them in mind. So as you can see, there's 5 here. We have the types of participants, then we've got the in-kind contributions. They're obviously both compulsory. We've identified it there. Then again, our friend EKAA, basically we will need information on that, and that should be completed by the actual private members at the relevant stage. So either, at the single stage or at the second stage of the 2-stage, that's when, as I mentioned, the pre-identified industry consortium comes in and they'll say, look, this is how we're contributing our 45%. Then we have a 4th annex, essential information for clinical studies, if your project involves clinical studies. And then last, we have ethics. Now, this is important. I mean, the main template already has a space there for ethics, but if you need additional room, if you need somewhere to put in additional information in relation to ethics, that optional additional annex is there for you as well, to make sure that you can address all the key points. And then just in relation to how we're going to evaluate these evaluations. So as we said, IHI, we will use independent experts. There'll be a minimum of 3 independent experts. So these proposals aren't evaluated by the IHI office to make sure that we're completely neutral and the evaluation is independent. These are independent experts who are brought in from outside. The key point for us is, and we said this all the way through IMI2, and we've got to say it here again, the experts will evaluate what is placed in front of them, and they're not going to speculate because that's the only way we keep it fair. So as we've said here, each proposal is evaluated as it is written, and not as either what could be or what the independent expert thinks you might be talking about, or what it would be excellent if the proposal did this. And we're very, very strict on this. They have to basically confine their evaluation to what is placed on the paper in front of them. There's 3 criteria standard across all the evaluations. That's excellence, impact, and quality of efficiency. And this is the key point. These are the thresholds. So for each of those 3 evaluation criteria, the threshold is 3 out of 5. So they're scored from 0 to 5. Obviously, 0 is really not good. It's almost ineligible. 5 is absolutely excellent, and there's no problems with it, and we really are very happy with it. So you have 3 out of 5 for all 3 criteria, but overall there's also an overall threshold of 10 out of 15. So you can score 4 here, 3 here, 5 here, but as long as you basically make an overall score of 10 out of 15, then you're meeting the minimum threshold. In terms of the momentum, after we get through the evaluation stage, as you can see here, we basically said it's 5 months for informing the applicants of the scientific evaluation and then 3 months more for signature of grant agreement. When I was talking about those consortium negotiations in relation to finalizing the consortium agreement and discussing the background and getting the access rights understood and all of that, it's anticipated that that's basically going to happen here in the second part within 3 months of that second stage when we're getting ready for grant agreement signature. You're finalizing the consortium agreement and you're finalizing everything else to get to launch the actual project. When this is happening, then obviously all the legal entities, they're basically making sure that they're getting validated in the European Commission tools. It's handled by the Research Executive Agency. Everybody's getting their picks. They're making sure that they've contributed the right documentation, and that, you know, all of this, when it's fed into the tools, they're going to show up and there's not going to be any red flags. Just a quick point here that the lawyers insisted we put in. So just in relation to the Ihijuu grant agreement, we're just going to say it's important to keep in mind that everyone is vaguely aware of the grant agreement. As we said, it's a new grant agreement. It's not clearly the same as the IMI2 grant agreement. It has 44 articles with the annexes, and I will remind you, Annex 5 is particularly important for IHI projects, and not just Annex 5, the part of Annex 5 which talks about those specific rules that apply to IHI calls in Annex 5. And the grant agreement is signed just by the Ihijuu, that's our executive director, and the coordinator, and then everyone else accedes within 30 days using the electronic accession form. So this is clear. And then as a second point, then I would say you have the consortium agreement, which, as I said, it's executed by the consortium members, and the IHI doesn't sign that, but the two should be harmonious. And it's very clear that legally there can be nothing in the consortium agreement which conflicts with the overall rules in the grant agreement. But I think that's generally understood and accepted. And oh, here we have our slide on this. So as we said, it's done by all the participants. IHI not a signatory. It sets out rights and obligations, governance, liability, IPR. It has to comply with the grant agreement. It's to be agreed before the signature of the GA. So obviously, so IHI, and this is clear, and we've done this before. The IHI legal team will advise the executive director to not sign the grant agreement. Your project will not start if we do not have clear and unambiguous evidence from the consortium that the consortium agreement has been finalized. And then after execution of the consortium agreement, we will request a copy, PDF is fine, of the executed consortium agreement for our project monitoring. So this is clear. And obviously then in relation to the consortium agreement, every consortium agreement is going to be different because it needs to be adapted to the specific needs of each Ihijuu action. There are, just like IMI2, there are a number of templates out there. I think there's a DESCA model which is available, but industry, I know for a fact, are also preparing, I think it's nearly ready, a specific consortium agreement template for IHI actions, and that's going to be hosted on the relevant private member sites. So there's plenty of options there. And again, even though you're discussing this between yourselves, if there's a particular legal point that you're not sure on, please feel free to reach out to the IHI legal team and we can assist. But your primary point of reference in relation to the consortium agreement is the other consortium members, because as I said, IHI, we're not a signatory. And then just very fast, just some points to remember, which is going to cover. So point one, I keep talking about this, but we really need to make sure we have this. In relation to eligibility, 3 independent legal entities established in a different member state, but we need 1 legal entity in a member state. So we can't have 3 members from associated countries. It is the consortium's responsibility to ensure that the 45% industry consortium contribution is secured, and we'll have a declaration for that. If we don't have that 45% contribution early on, then the proposal is declared ineligible and we won't evaluate it because we have no room for maneuver on that. Second, this is just general advice. Again, from our experience in IMI2, we cannot overemphasize this. Please read all the call relevant material, the call topic text. Make sure you actually understand it, any supporting material. Start forming your consortium early. Start reaching out to potential partners early. As Catherine has referenced, we have a brokerage event next week. We're all going to be there. And I think events like that are useful to identify potential partners who may be able to support, contribute, or participate in your proposal. As I said, carefully read the topic text. Ensure that all information is explicitly described in order to allow expert evaluators to assess against the evaluation criteria. We're super strict with the independent experts, and we insist that they only mark what they can see and what they can read. So you have to be extremely clear, extremely precise. And as I said, for that, your best ally is brevity and precision. Next, use the proposal structure template. I mean, I think this is clear. You'll have to complete your ethics self-assessment. That's in the template. And complete accurately the researcher's table in Part A and ensure a gender balance. The gender balance is important, and we will look at it. And if we have completely equal scores in relation to the evaluation outcomes, then we will look at this in terms of weighting. The proposal should respect the page limit. I've already said that. If you plan, and this goes back to the question we received, if you plan to be the consortium coordinator, ensure that you're financially viable. This is Plivius's point, and I agree completely. Otherwise, it can derail a application preparation. So if you're gonna put your hand up for coordinator, make sure you're viable. Please, when you have the proposal ready, finalize and submit early. Don't wait until the crunch. And also, if there's any queries, you contact the IHI office, not the individual industry topic writers. That's a no-no. And we've put the link for the input desk there. And just in relation to timelines, very quickly, we have there in big bold letters, this is indicative, but for the call 1 stage, we're talking about launching at the end of June. Call submission deadline for full proposals, that's the 50 pages for stage 1, or single stage, that's at the end of September 2022. Then we do the evaluation. We'll have information out to the applicants by the end of November. And theoretically, if all goes well, we could be looking at signature of GAP, or signature of the grant agreements in March next year. And if you have experience in IMI2, you'll know how fast the months go by. So again, please, you need to start and self-organize early. And then obviously the 2 stage is a bit more complicated because we have the additional tier evaluation, but we're launching at the end of June. Again, end of September for the short proposals. That's the 20-page proposal from the applicant consortia. Then we have the evaluation, the competition. Then we basically merge the 2, and we're looking at a second round of evaluation outcome letters going out in April. And then we basically have GAP for that, indicatively timed for July next year. So literally this time next year. And just some reference documents. So we have a lot of documents here. All of these are useful, but for the purposes of the slides I've actually covered, I'll identify 3 key documents that I cannot urge enough everyone who's on the call, link right now, find it right now, and put it somewhere where you can always access it, because you're going to be constantly checking these. So I would say, 1, the Annotated Model Grant Agreement, the Horizon Europe Annotated Model Grant Agreement, which takes the grant agreement and explodes it with best practice notes, annotations, explanations, examples, and it grows the text from the model grant agreement. I think is about 100 pages. This adds about 200 pages of additional explanation, and it's incredibly helpful. The last version, as I said, I think it's the 16th of December 2021. It's Googleable because I checked this morning. Get it, download it, print it out, and make sure you have some familiarity with it. The second document I referred to in these slides as well, and that's the Horizon Europe Program Guide, because that gives practical information. It also identifies the low and middle income countries, and it also talks about the associated countries. So if you have that with the AGA, I think in terms of the general rules, you're actually in quite good shape. And then third, there is a separate and constantly updated list of associated countries. So for instance, if you're from the UK or if you're in Switzerland, that separate list can actually be hugely useful as well. So they're the 3 documents I would really emphasize just for the purposes of this call. We have some of them listed there under the HE reference documents, and all of these would be useful, but I would really emphasize those top 3. And then for the lawyers, obviously, we have the Horizon Europe Rules of Participation. We flagged the SBA there as well, and the SORIA. So this is all useful as well. More information. Obviously, as I said, we have the applicant's functional mailbox, and you can also reach out to your member of the state's representative group, which obviously are heavily involved in this, and the link is there. And that concludes the information part of our session, and we've already done quite a few of them, but we're happy to take any further questions if anybody has them. And before we finish, I'd like to thank you for your attention so far.
Okay, thank you very much, Desmond. That was a epic presentation, but I mean, this is a new program. So there is a lot that is new for all of us, including us in the IHI staff here, to learn and to understand. And also for you as applicants, this is obviously new. So going back then to some of the questions, and I'm aware that we've run over time, so I think we'll try and answer these ones briefly, but we will try and answer them. So there was a question on ICA. Does that fall under the definition of results, and hence under the access rights for results as defined by the grant agreement?
Oh, that's actually quite an interesting question. No, because I mean, as I said, I mean the results. Let me just check the exact wording of the question. What results generated through ICA fall under the definition of results? So, as I said, results are stuff that are coming out of the actual project. So, ICA, as we said, generally doesn't involve actual project activities because then it would be ECOP. So as a first point of reference, I would say generally no, unless the ICA is so deeply integrated and it's in the description of action and it happens inside the time frame of the project, and then we may need to revisit it. But I would say as first point of reference, I think it's clear that, you know, and the other issue is, as we said, ICA, a lot of it is going to come in after the end of the project in kind of a supporting fashion, whereas results under the legal basis, and as I've mentioned, results are generated during the time frame of the actual project. So, you know, it's hard to see an interface between EKA and results. It's possible it could happen, and then we'd have to look very closely at it. But I think as a first point of reference, I would say generally the two should be contradictory. But like, you know, anything is possible in IHI. So,
this is new. Everything is new.
Yeah.
But instinctive reaction is it probably isn't possible by definition. Okay, so someone is saying without a strong engagement with the members, providing this 45% as proposal wouldn't be possible. I mean, as Polivios said earlier, we are a public-private partnership, so our projects should reflect that. So yes, you do need that engagement. Have projects chosen the projects they will finance? I mean, again, this is why we're having this brokerage event, why we have the networking participant lists with the webinars as well. So, I mean, they're there. And are the industry partners invited to the brokerage event? Yes, they are. And some of them will be pitching as well, I think. So, yeah, I'm getting nods here from Tom. So, yes, I mean, there is also at the brokerage event going to be a pitching session, and a lot of people who are coordinating proposals, including industry partners, will be presenting there. So do watch the brokerage event, watch the pitching sessions, and that will also give you some useful leads in identifying these people.
In relation to just that previous question, I think it's coming from Valentina. I would just flag one thing. The question is, industries have already chosen the project they will finance with 45%. What I would say is, particularly in relation to call 2, but I mean, both our single stage and our double stage are clearly competitive, transparently competitive processes. So, but I think this is particularly clear in relation to the second stage or the 2-stage process. That predefined industry consortium has absolutely no influence on the applicant's competition at stage 1. So they will link up with whoever wins the clearly openly competitive round 1. So all they've basically done in the call topic text is said, this is a topic that interests us. These are the private members who are participating, and this is indicatively the resources that we are bringing. And we're sitting there waiting at the second stage, and we will merge with the winner of the first stage, whoever they are, unless there's something absolutely unexpected. So I think it's very clear. It's important to make very clear that, you know, there's no pre-selection ongoing. And obviously, rules are slightly different in relation to the single stage but then you have spontaneously self-organizing consortia, and industry will just engage with whoever comes up with a good proposal, I guess.
Okay, someone is asking if you can define associated partners and third parties. I think this was already covered in one of your slides, actually. So I don't think we need to go back over that, but I would say go back to the slides. And if something is still not clear, go to the documentation and come back to us.
And please go into the AGA. And I would basically say, I mean, the key way to define them is they're not actually signing the grant agreement. They're not acceding to the grant agreement, but they are actually providing something to the project. And then that's where you get the distinction in relation to the third party and the AP.
Okay. And someone is talking about a stage 1 here, so I assume this is a question about stage 2. Should we invite the IHA industry partner while writing the project, or will IMI do the matchmaking after the stage 1 evaluation? So again, as Desmond said, the matchmaking happens after the evaluation. So the applicant consortium without industry partners puts together the proposals. Those proposals are evaluated by independent experts, and the top ranking consortium of applicants goes through and is then linked up with the industry consortium, and you put together a full proposal, and then you go and that full proposal is evaluated again by independent experts. And then, okay, there's no competition at that stage, but it is go, no go. And as Desmond explained, there are thresholds for the evaluation. And if it doesn't meet those thresholds, it won't be funded. So it is still a serious evaluation. Next question. I'm getting scroll signs here, so I will let Desmond can shout when I get to
who can lead coordinate? I mean, I think we've answered that question already. This is fine. 2-stage calls, a single project will be funded. Yeah. Could you make? Can you make it to the second submission work? Oh, yes. I think that. Sorry, I think this is actually an interesting question. I think the key point is that when you have the applicant consortia, it's going to be very clear who's eligible for funding and who's not. I think that will be established at stage 1 during the applicant. So if you're eligible for funding at stage 1, unless something dramatic changes in relation to the organization of your own legal entity, which would affect the categories that we talked about. For instance, I'm thinking, for example, you start as in the applicant consortia as an SME and your overall annual turnover is under 500 million. And then when you merge with the predefined industry consortium and you're getting ready for grant agreement, and then you're bought out or you become part of a larger corporate group whose turnover is clearly over 500 million, then I think for the purposes and for narrow purposes of this scenario that we're talking about, then yes, your funding eligibility would change. But I haven't actually seen that happen in practice.
But I think this is more a question actually about if you make it to stage 2, does it sometimes not pass? And the answer is
then the answer is yes. So as I said, I mean, we have the second evaluation stage to make sure that when we have this full consortium, that what they're actually doing is still aligned with the topic text. It's still a worthy project, and it's a good gatekeeping mechanism. And in the past, in IMI 2, we did occasionally have these fully formed consortia, and they didn't succeed at the second stage.
Okay, there's a question here again about ICA. When is it going to be approved, and is it relevant for the eligibility of the proposals? And can single stage proposals include ICA?
Yeah, so I mean, EKAA, essentially what's going to happen is EKAA is going to be identified on an almost annual basis, and it will take the form of an EKAA plan. And basically those members that are contributing towards EKAA, they're basically going to put together these assessments, and then this is going to be reviewed by the actual governing board. So I would say that in terms of the eligibility in relation to the applicant consortia, this is less of an actual issue. It's anticipated that single stage proposals, if you want to reference EKAA, I think you can actually make the reference. But there's flexibility in relation to it, because we recognize that EKAA, it's something external to the actual project. It's something which is external to the operational in kind, and therefore it's under a slightly different regime.
Okay, next question, and I think this one we've already covered.
Yeah.
The another ICA question for you.
Yeah.
For example, a large industry member has 5 million euros of ICA fully linked to the IHI program objective covering the full IHI program lifetime.
Mm-hmm.
How do you define a part of this 5 million euros to be linked to an individual proposal? And where the IHI office mentions to keep the maximum of 40% ICA rule on project level.
Yeah, so as I said, I mean, the plan is, and we're still evolving this, the idea is that there would basically be an annual EKAA plan where the private members will basically designate we're contributing this amount in 2022, this amount in 2023. That's going to be reviewed by the IHI governing board. So you don't have to allocate it all in one chunk. But basically what you would do is you'd basically say, of our available EKA, we're going to allocate, for instance, 1 million to project X in call Y, and it would be accepted on that basis.
Okay, someone is asking where you can find the AMGA on the IHI website. It's not actually there yet. We are putting together a page of all the call documents.
Yeah.
And that will be published when the call is goes
Yeah,
live.
but if you
It's on the
Google
Horizon Europe.
Yeah, if you Google it, you will actually get the Horizon Europe. As I said, I double checked this morning. If you Google it, you will see the annotated grant agreement is available for download, and it's the Horizon Europe AGA.
Okay, so it will all be there on the IHI website, though. Don't worry when the call is launched.
Oh, actually, that's a good point. Sorry, you've just prompted this question. I should clarify. Indeed, for IMI2, the legal team spent an awful lot of time and effort putting together a dedicated IMI2 annotated model grant agreement for IMI2 actions, particularly because we had all these specificities for IMI2, like FIC in kind. But because now we're essentially using the corporate model grant agreement, we don't need that. So you can actually use with confidence the Horizon Europe AGA. So thanks whoever actually asked that question, because you've highlighted something that maybe I should have mentioned earlier on.
Okay. I have a very concrete question here. Are university hospitals considered as industry and therefore may need to contribute funding?
Instinctively, I would regard a university hospital as a non-profit or a research institute who would be a beneficiary receiving funding. So again, they wouldn't be contributing to the 45%, but I think that they should keep that in mind in terms of the larger consortium interactions.
Yeah.
Maybe here it's very important to say industry is one thing.
Yeah.
Being a member of the undertaking, a member of the association, is another thing. So when it comes to the 45%, this has to come from the members. So even if you're an industry and you're not a member of the association, this will not be counted against the 45%.
Actually, that's actually quite a useful clarification, actually. Yeah.
So is the membership the key point here, not if you're an industry or not. As an industry, you can be part of the consortium, you can receive funding or not. But the 45% has to come by the members, and the membership verification of this 45% will take place in principle before the grant agreement signature. So even if you're not a member in the process and you would like to join one of the association, you have time to do it before the grant agreement signature.
Okay, another question here about how to apply. If a university is interested to apply in one of the topics, should they have to get into a consortium with industries contributing 45%? Is this correct? I mean, the short answer is yes.
Yeah.
For the single stage topics. But in any case, whether it's stage 1 or stage 2, if you want to apply, you need to be part of a consortium. You can't apply just as a university, so you will always have to find a consortium. And if it's a single stage topic, you will have to find a consortium that has contributing partners or industry in it as well. Okay, moving on. So I think this was touched on a little bit already, so I think we can move on. And then there's another question. In single stage calls, can hospitals and national funding provide parts of the 45%?
No, I think Flavius has answered that quite clearly as well. So.
Okay. Okay. So if I understood well, for the 2-stage call, the results of the first stage will be published 6 weeks after the deadline. Why is the grant agreement expected to be signed 8 months later if there's only one consortium selected?
No, so as I said, I mean, the plan is we'll basically have first the applicant consortium, which prepares the short proposal. Then we have an evaluation round for that. Then the winner of that is then notified. Then that winner merges with the pre-identified industry consortium, and then the two of them prepare a second proposal, and that's the full proposal, and that goes to another round of evaluation. So you know, that 8-month period is fully utilized to allow after, if, as I said, we have this gatekeeping mechanism, which is the second evaluation. If they pass that, the second evaluation, then they still need several months to basically prepare the consortium agreement, do consortium negotiations, and get ready for actual grant launch.
Okay. A few people have been asking, I mean, we mentioned it at the start, but the recording and the slides are all going to go on the webinar page. And for the person looking for IMI projects, including participants, those are also on the IHI website as well. There is a question here on IP. So on the issue of objecting to the transfer of ownership of results to outside the EU, how does that work for beneficiaries not receiving funding, for example, with their legal entity based in the USA?
Yeah, that's so. we just had a meeting on that this morning. Basically, the situation is, okay, in its broadest terms, as I said, if we basically see a result which is going to be transferred or exclusively licensed outside the EU, the Ihi JU has a right to object. So if you were going to do this, there is a pre-notification mechanism whereby you notify the Ihi JU and say, we've generated this result, we want to transfer it outside the EU, do you wish to exercise your right to object? Now, a couple of points here. We have established, the legal team for Ihi have established that this can be done if time sensitivities are a factor. This can even be done prior to results generation. However, it is unavoidable that whether you are a beneficiary receiving funding or not receiving funding, the Ihi JU for calls 1 and 2 does have this right to object. Therefore, if you're unsure about this, the best advice I can give you is to actually contact the Ihi legal team directly, and we're happy to go through the nuances of this, because like IPR, we could actually spend several hours just on this particular subject.
Okay. Another question: what are the profiles of the independent experts?
I mean that's more a matter for my scientific colleagues who spend an awful lot of time vetting and getting the experts. But I mean, it's clear that they're established authorities in the field. They have the requisite qualifications, and they're on the list. So Polybios may be able to give a more detailed description on that. But I would say that they're clearly defined and accomplished professional experts who we trust to give an informed, independent opinion on the evaluations that are put in front of them.
Exactly. First of all, the experts are selected based on the topic needs, on the expertise required. So based on this expertise required, the Ihi program office and mostly the scientific officers are searching in the database of the Horizon Europe. And maybe it's a good opportunity here for the ones that you have the scientific expertise, or competent experts in the field, to ask them to register in the list of the Horizon Europe, that you can find the link very easily in the funding and tenders portal, and you can actually even inform Ihi about your registration, so you can go and check your profile, and we'll see if you fit in terms of the expertise required for a specific topic. But these experts are independent, they don't have a conflict of interest, and of course this expertise is checked based on publications, based on the experience, because the registration will require to provide all the evidence of this specific expertise. And in Ihi specifically, we try, of course, we cover the full expertise of the topic. It's not only one expertise needed. We have to see the topic and the evaluation from all perspectives. So have a variety, let's say, coverage, and we use even more than 5, sometimes, experts to evaluate each proposal, and the minimum is only 3. But in Ihi, in order to be 100% sure, in order to coverage the full spectrum, we invite more experts per proposal to evaluate.
Okay, thank you, Polybios. Another question on the famous 45% and the industry consortium. Are the available partners in the pre-identified industry consortium the same for all applicants? And are they necessary for the second stage calls? And are they responsible for the 45% in kind in this case?
Yeah, so by answering this, I'm going to touch on some points we've made a couple of times previous, but I think this is actually a good question because it kind of shows the through line of the process. So what I would say is, as we said, in a 2-stage call topic text, we have in the document right from the start, day of publication, we have the pre-identified industry consortium, and it lists who they are, and it lists what their contribution is actually going to be, what they're bringing. Now, it is indicative, but it's generally pretty accurate. Now, what that basically means is then that they're completely necessary for the 2-stage calls, because we need a predefined industry consortium who are going to contribute in kind when we have the winner from the first stage, which is just the applicant consortia. So I'd say, yes, they're absolutely necessary. I would say that, and I said this earlier, for the predefined industry consortium, their interest is who's going to win the first round, and then they're ready to merge with the winner. So they don't have any vested interest, in the first round in terms of, individual consortia. And then in relation to the 45%, yes, I mean, this is the whole point then. When we integrate them, with the winner of the first round and they form what we call the final consortium, then it's the private members here who are the identified pre-identified industry consortium. They're basically then contributing the 45% in kind. But I cannot emphasize this enough, and this is why I picked out this question in particular. Yes, the industry consortium are responsible for providing that 45%. I mean, the private members are, but it's the responsibility overall of the entire consortium. And as I've said multiple times, this needs to be thought about as early as possible to make sure that that when you get to the relevant stages, the consortium can say we have the necessary contribution ready.
Okay, there's another question about additional activities and what this constitutes. There is actually quite a range of activities and then subtypes of the different categories. And again, all of this is in a document that will be published on the website shortly around the time of the call launch. So I would say I would have a look at that once it's published. And then, of course, if you still have questions, you're more than welcome to come back to us. But that could be the subject of a webinar all on its own, and maybe it will be one day. Again, the presentation and recording will be online soon. There's a question. Are the topics of the one-stage proposals prepared by industry partners? I mean, it's more like
that generally, or are they talking about? I mean,
Polybios,
yeah, Polybios, you might. Yeah, I think you've been dealing with the topic writers.
Expert on topic development.
Yeah.
Sorry, Catherine, can you please repeat the question?
So the one-stage topics, are they prepared by industry partners?
The single-stage topics, the drivers are is a program office. We are the pen holders. It's the Ihijuu program office who is drafting the topic text, but of course there is a consultation with the wider health community, with the science and innovation panel, also with our finding members. But it's the program office who is drafting the topic text. We are the pen holders. Now, for the two-stage course, of course, it was described by Desmond. The driver is the industry, the private members who are interested to this specific scientific area and the resources that they will put for this specific topic they're interested in.
Okay, so I think we've come to most of the, this is a good question which we often have. Is there a maximum number of members that should be in a consortium?
I mean, strictly legally speaking, no. And in the past, we've had some very large consortia for some IMI2 projects. But I mean, I think Polybios would agree with me, and I know the scientific officers would. I think there is a natural, practical limitation where, in terms of just getting work done and liaising and all the rest. But so you can have consortia with several dozen members. This is fine. But there comes a point where the size, the number of necessary interactions, and even something as relatively mundane as getting the consortium agreement signed becomes extremely challenging because there are so many beneficiaries. So I would say there's not a hard fast rule, but it becomes almost a self-governing kind of process where you basically identify the key players who are going to make the contribution or do the work or bring in the background, and then basically you have the additional ones you want as well, and then that kind of becomes self-limiting.
Desmond, we can make the long story short. The consortium members need to have a valid role. This is part of the implementation criterion, and it will be assessed. So the tasks that will be undertaken by this participant should be core task essential to carry out the work of the action. So the validity there will count for the assessment. There is no number, but the tasks and the allocated resources talk. And this, what I mean talk, the experts will see and assess on the overall and for the specific participants, and then they will have also their scores accordingly.
Yeah, that's actually a good practical point as well. Definitely, I would agree with that 100%.
And there's a comment as well, just saying how we can put in place spaces for interaction between IHI members and potential consortia. And I mean, yeah, this is why we've put in place some of the things. And I mean, this is something that we're really exploring how best to do this and to facilitate this, while, of course, as we mentioned, respecting the fact that these are competitive calls. But this is something we're very aware of, and this 45% and having all these single stage calls, it's new, and we are aware. That's why we're doing things like the event on Tuesday. And I would say as well that the website, if I'm not mistaken, the brokerage part of the website to allow people to find each other and put up profiles, that will remain active after the event as well. So people can still.
That's right. Right up to the call launch. That'll go for 2 extra months.
So, you know, you can keep using that. Okay, we have come to the end of the questions. So thank you very much to Desmond and Polivios for answering them all and for giving extremely long, extremely detailed, but hopefully very useful presentation that really covers all of the aspects of this new program. We obviously haven't touched the topics, and as I said earlier, we do have webinars on all of the topics over the next couple of weeks as well. And I would again encourage you to go to the website, have a look at the draft texts that are there, and have a look at the final text as well, because, you know, there may well be changes between the drafts that are there now. So on that note, I will say thank you very much to all of you for joining this webinar. And again, if you have any further questions afterwards, don't hesitate to get in touch with us. Thank you very much, everyone.